I am honored to be joined again today by author and lawyer at UC Berkeley and an op-ed contributor to the Washington Post and NBC Think and others, very important writer and voice. Please welcome Teri Kanefield. Teri, hi.
Hi.
So we had a very enlightening discussion on Twitter over the weekend because the White House on Friday formally blocked an attempt by Donald to withhold documents from Congress related to the January 6th attack on the Capitol. And, media reporting is that this is setting up a legal showdown between the current and former presidents over executive privilege. And I don't know if it's much of a legal showdown, but I was wondering if you could give us your top line thoughts from a just security piece that you published.
Well, top line would be, if Trump picks this battle, that would be very stupid. And actually stupid is a well-recognized legal term. I'm only speaking at the highest levels here. It would be dumb. And so whether he's going to do it, I don't know, but it would really not be a good idea for a lot of reasons, which we can, sort of talk about what the process would be, what the law is, what would happen. But the bottom line is, actually the sort of bottom line is, he would not just lose, but he would trigger a very bad ruling against him, which would be that the documents that he's trying to conceal contain evidence of wrongdoing. And so right out of the gate, he'd get a ruling, which is what he's trying to prevent. So he's better off letting it go. Does that mean he will? And also the other thing I'll say is that, I can walk through like what the process is, what's probably going to happen, but ultimately nobody really can predict a court.
Yeah, and we've covered extensively, like, for example, the raid on Cohen, the raid on Rudy, and how the court appointed what's called a special master, in both cases, retired Judge Barbara Jones, to go through the tranche of documents and determine what is or isn't covered by attorney-client privilege in those cases.
Let me just interrupt and say that's probably not going to happen in this case.
Right, and
it would be that's very unlikely because it's a different standard. Mm-hmm. So what's being asked is a different question at the threshold, and so I don't think, and if I'm wrong about this, then then what, I guess I'm wrong about it. But I from everything that the law is indicating is that it's a very low standard here. And if these documents, and it's not like document by document. So, and because of the exception that would be raised. So in that case, they were just looking to see whether the material is covered by the privilege. Right. So each piece then has to be looked at. Is it covered by the privilege? Okay, which would mean, is it something confidential between the lawyer and the client, and not like, let's meet for lunch tomorrow. The assumption is all these records are confidential presidential records. So you don't have to do that.
Right. I think the only kind of tie that I was trying to make there is what's considered, at least in a special master case, is what's called the crime fraud exception, which is where you're saying Trump could set himself up for a bigger loss than to just let it go. Because if the court or the National Archives determines that the reason that these documents aren't covered by executive privilege is because they were in the furtherance of committing a crime, that is a ruling, and that's, I think, what you're.
And that could be quickly.
That would be very bad.
Because you don't need much. So what we don't really know the standard. Okay, so to back up, no court has ever had occasion to say that the crime fraud exception applies to the executive privilege. And that's because no president since Nixon has ever tried to prevent the courts from looking at any material which may implicate the president. And the reason is because they don't want that ruling. So they've never tried to do it. So we don't actually know what the procedure looks like, but what we have some language from courts in the past, and the DC court is the court that this would go to. And the DC court in the past has said that I can look the quotation up for you, but I can do it pretty close off the top of my head, that if there's any reason to believe, that there's criminal, that the evidence contains any evidence of criminal wrongdoing. So it's a fairly low standard, and you already have that. So records are due. You said you work in archives or you generated records. Records tend to be duplicative, right? So if the president sends an email to somebody else, then it's in several places. If there's an email between the DOJ and the president, then it's in the White House, it's at the DOJ. We already have evidence that we know would be in those documents that indicates criminal wrongdoing. Now, the criminal wrongdoing doesn't have to be big. It doesn't have to be big. It can be small. It can be a Hatch Act violation. It can be something that we know Trump did, was try to prevent the electoral votes from the electoral count from happening. And so that is illegal. So it doesn't have to be some big thing that he wants to overthrow the government. Very small violations are in there, and we already know that. And so it's not like they have to go through piece by piece, because the argument is that what Trump did over time was create not just incite an insurrection, but he created a sort of an environment for disinformation over a period of months that created the groundwork for the insurrection. So you can't go piece by piece. Anything connected to and they're not asking for all the records, right? They're asking for all the records related to January 6th. So that's why I say it's not like a special master has to go through. All you have to do is show that there's some reason to believe. And since it's such a low threshold now, the reason this is particularly treacherous for Trump is because Biden is going to go in there and argue against him, and so is the DOJ. And also, it looks to me like Trump can come in as a person, but he has no special standing as a former president. So it would be like you going up against the DOJ and the White House. So
I've tried it. I failed.
Well, you know what? You may be braver than Trump. So it's such a low standard, and it's not like, did this phone call over there about, so basically what the special master did in the Cohen case, the archivist has already done, which is pick out what is responsive to the request, which is probably all privilege. So then the question is there any evidence in there of wrongdoing? And so I think the way it would happen procedurally is the best guess we can make is that the procedure would be the same as with attorney-client privilege, which comes up on a motion. So what would happen is Trump would file an appeal, and what would he appeal? He would say the materials are, number one, privileged, and number two, I control the privilege. Okay, so talk about uphill battles in both cases, right? That's what he would do. He would file that, and then the Biden administration or somebody's going to come in with a motion and say we need this whole thing dismissed because there is no privilege. And there is no privilege. So a court doesn't come to an abstract ruling if there's no privilege.
Well, right, because Teri, they can cite Nixon. And then they can also cite the executive order written by President Obama that puts the determination of executive privilege only on sitting presidents. And that's, I think, a big deal. But I have an interesting legal question for you, because you and I sort of talked a little bit about this over the weekend. We know that, why didn't Trump, before he left office, put out another executive order saying that former presidents have executive privilege? And does that evidence that he didn't indicate some sort of intent that he felt that he had the election wrapped up, when you look at the Eastman memo and when you look at the Jeffrey Clark letters to the same 7 states to overthrow the electors, and the meeting with Pence to go over the 6-point plan for the coup written by attorney Eastman, who, by the way, should be disbarred. But is there any way to add that to the totality of the evidence that he was certain that he was going to quote unquote win this election by simply not giving himself the privilege and revoking that Obama executive order before he left office. It just seems like a dumb move if you're going to try to.
I think there's another thing you could do. I think that would probably be too tenuous, and you've got better evidence than that he's trying to overthrow the election. But actually, by the way, what I didn't send you after I sent you the executive order is Congress actually codified that. So Congress actually added that. But the same argument holds. So I think it's a different legal argument that goes like this. Because it's too far away to say, we don't know, maybe he just didn't think about it. Who knows? But there's a lot to think about. And he, whatever, he's busy watching cable news, trying to figure out his next, his next move.
Had Eastman put that made as a 7-point plan, and step 7 was.
It would have probably had to have been done way before then.
Mm-hmm.
It would have had to be, because the law was put in place in 2014, so he had 4 years to do it. So I think, so it wouldn't have been so easy for him to do it, but it would have been fairly easy. So there's a thing called estoppel, where you're prevented from doing something because you participated or you made a promise or whatever. So if Trump's argument that he should have the privilege and not Biden, or equally with Biden or higher than Biden, that basically the former president should have the same rights or more rights than the incumbent president, that's what he's going to argue. So basically, the only way you can argue that right now in court is to say that the law on the books is unconstitutional, because the courts apply the law, and the law says that the privilege is held by the current president.
And you'd also have to show that the Supreme Court, you'd have to overturn a previous Supreme Court decision to release documents from a former president in the Nixon era, because I think Nixon tried to do that too. Actually,
yeah, but these laws were put in place since then, so you can't go back that far.
I gotcha.
Okay, so walk it step by step here. So while Trump was president, he knew that the law gave the privilege to the sitting president, not the former president. He knew that, and he never tried to change it. So his argument right now, so courts apply the law unless the law is unconstitutional. Okay, so Trump can't go in there and say, don't apply the law as it is, unless he also argues that the law is unconstitutional. He'd have to raise a constitutional argument for the fact that the law cutting him out of the process is unconstitutional. So can you say that a law that you approved of while you were president is unconstitutional? I mean, it seems like you're sort of stopped from doing that. So
that's my concern, right? Is that the Supreme Court would rule that this law that was codified based on the Obama memo, or in conjunction with the Obama executive order, saying that the former president can't exert executive privilege.
Okay.
That's my concern.
Right. He doesn't have okay, all right. So you're not going to get to that question unless you first determine that the material is privileged.
Okay.
Okay, okay. So I hope you're like wide awake next time. It just like messes with your brain, right? Because you're not going to question whether Trump holds the privilege unless there is privileged material.
So it's just like that sort of order of operations where the court must first determine standing and jurisdiction before it can look at the merits. The court would have to determine that these are actually privileged documents before it determined that the law preventing them from being released was unconstitutional.
Right, but the more direct reason is that a court will only consider a controversy, an active controversy. But you're right. You've got it right. Another way to think of it, I should say, is that there has to be a controversy. You can't go in and say, so if there were privileged documents, I should have jurisdiction over them, right? Or I should have authority over them. There has to actually be privileged documents in order for him to assert there has to be privileged documents for him to assert it. So
because you need to show harm and then have a remedy. Is that
okay? So Trump has to say, okay, so he says actually, right. So Trump has to say that the documents are privileged and I control the privilege. Because because he doesn't control a privilege if they're not privileged.
Mm-hmm. Yeah.
Right. So let's say there's nothing happening right now and there's nobody asking for any documents. Trump can't go to court and say this law is wrong, take it off.
Mhm. And he
Because-
also can't go to court and say, release all the green documents, but all they want are yellow documents. It doesn't stand to
So
reason.
he has to, so the only way for him to be able to argue that he controls the privilege is if there is a privilege. So the threshold question,
Oh, of
Yeah.
whether there was a crime or what? Oh, yeah.
whether they're privileged.
Mhm.
Okay, so I'm going to turn the page here because it's because I wrote it out so I wouldn't get confused because it's confusing. So Trump files a lawsuit he would file a lawsuit and he would name the archivist in the lawsuit, and his lawsuit would be attempting to prevent the archivist from releasing these documents to Congress. Okay, on the grounds that number one, they're privileged, and number two, he holds the privilege.
Mhm. And you
So-
have to answer one before you can answer the
Why?
next.
Because if they're not privileged, then the issue doesn't come up who holds the privilege.
It's moot, right? It just,
Yeah, it doesn't even, it's like moot, it's like never even there, because it's like if there's no traffic accident, you don't have to decide who's at fault.
right. So if I'm in the DOJ, I file a motion to dismiss because the situation is moot because these are not executive privilege.
So
We
what
don't
I
even
would-
have to
right.
answer the question about whether or not he holds the privilege.
I agree. So I think what would happen, and again, since it's never happened, I'm making the best guess I can based on the fact that what I'm looking at for how it would work is how it does already work, how the crime fraud exception works for attorney-client. So in attorney-client,
And deliberative process and.
yeah. And well, what happens is it's on a motion.
Mhm.
So a motion it happens before a trial and before the big deal, right? So this is preliminary matters. So the first thing that happens, you file a lawsuit, and then there's a bunch of motions. Dismiss it because of this and whatever. So the first thing that would happen is somebody, and the court on its own could do that. The court in DC could say, wait, are these really privileged? Do we even have a controversy? And so Biden or somebody else or the court on its own says, we're going to file a motion saying that the crime fraud exception exists. So there's no privilege here. So the threshold question would be, is there a reason to believe that there's evidence? And you don't have to find, it's not a finding of guilt.
Mhm.
All you have to do is say there's some reason to believe that there's evidence of wrongdoing. That's all.
I might even file a bill of particulars, any other pretrial motions, not considered, being like, hey, you're going to need to explain to us why these aren't privileged, and then see what he has to say. But that would just probably be kind of a waste of time.
Yeah. So the question of whether he holds the privilege, no, I don't think he does.
No,
Right.
I don't think he does either. And I want to ask you about the process too, because we've got this 30-day, 60-day, 90-day. We have all these questions that we talked about this weekend, but I have to take a quick break. Will you stay with me?
I will.
Thank you. Everybody, we'll be right back. Everybody, welcome back. We're talking with Teri Kanefield about executive privilege and the January 6th committee and documents from the National Archives. And Teri, there seems to be a bit of a back and forth on social media because of some Politico reporting and some MSNBC reporting saying that there is a 30-day window after the request for these documents, which I believe went out on September 8th from the January 6th committee, must wait. But I don't necessarily think, based on the language in the law or in the executive order, that they must wait for an appeal from a former president, particularly since Biden is not, he's waiving his executive privilege over this matter. And that seems to me that as soon as that document request is made, that the National Archive, I feel like no one has to wait to see if Trump wants to object. They can just start rolling these documents out. But what did you come up with?
Well, I agree with that, but okay, a couple of things. The first is, okay, actually one thing to make sure everybody understands is that we're only talking about a small fraction of all of the documents that the Congress is requesting. They're requesting documents from DOJ, from lots of other agencies. We're talking only about the presidential documents. So we're talking about a substantial part, but a part. And that's the only place where Trump can stop things. So the committee is getting lots and lots, probably millions of documents coming at them right now. So it isn't, if they did wait, it doesn't really slow them down because, like I said, a lot of it's duplicative. They're getting records from every place. So on the one
Plus, it
hand,
also takes time to go through and omit the duplications and get the documents ready.
right, it's not like so let's say they wait for 30 days or whatever. It's not like they're sitting around waiting. So it's not like there's like this urgency that, oh my God, we better do it now, because there's other things to do. So I looked at it just like you did, and I could see an argument for the time starting after the records are selected. Because after the records are selected, then presumably what people do is they look at each record, they decide record by record. But since Trump is just a person and not the president, it's really not clear exactly when that time started. It's not really clear whether there even is a window. But I'll tell you what I would do if I was advising the committee. I would say, don't take a chance, because who cares? Don't mess it up. So since it doesn't matter, you're not waiting, give the benefit of the doubt. Because if for some reason someone comes along and makes a really clever argument that you shouldn't have done it, you could compromise your investigation, and you could compromise the committee.
Due diligence, cross your T's, dot your I's.
Yeah, don't, because it doesn't matter. Now, if they had nothing, okay, so things went, remember, things went very, very fast with those court filings with the election fraud, quotations around fraud. They went very fast because they knew that they had to get this resolved before January. None of those courts wanted Trump to get away with tying things up in court so that the election couldn't be certified. So they had a deadline. The committee has 2 deadlines that I've heard. They want to get the bulk of this work done by early spring. And of course, they're looking at, they want to have it done by November, everything done by November. So there's nothing in what the committee needs to do that says we better like take a chance and jump the gun and get everything right now. So I would advise not to. And also, I have a feeling, but I don't know. I have a feeling that because some places are reporting that Liz Cheney said there's 30 days, whether or not these parties are talking, Trump's lawyers are talking, and whether or not there's some agreement or some concession or some, we're so used to kind of like the fight thing, be mean, be harsh, like play hardball. The reality is that these things, the lawyers get together and they're not like duking it out. They're saying, okay, fine, take 3 weeks. What do you need? Don't rush it. I mean, don't tell the archivist, do it now, even though, like, why make that kind of trouble when you're not facing a deadline? Like 3 weeks from now, the election needs to be certified, so we can't hold this up. Really looking at the spring. And so I don't see where, so in some ways, I sort of came up with, well, it's hard to tell exactly, but it doesn't matter. I would say, and this is, I think, where social media loses its perspective on things. You know what I'm saying? Like, oh my gosh, the Democrats are just a bunch of weaklings. Let them have 30 days. What are you, like, rolling over? It's like, no, that's just
why would you give the other side that argument to make when you can take it away by just waiting?
Right, but also it doesn't hurt you. I'm sure they're not giving anything up by waiting. I'm sure they're not with idle time. So, but also, for all we know, really, what happened is Trump said, I really need some time to think about this. And so I really want, give me 30 days. I really want some time. And they'll say yes, because they want to cooperate. They're trying to get cooperation going, right? So you don't deny a request. I mean, and again, we don't really know what's going on back there. And I, like you, I didn't find any place that said there's a window for appeals. I see places where you can read that in, you can see how someone could come up with it, but where does it start? But one of the things that the committee said was some of these witnesses are in good, looks like what they're considering sort of good faith. They didn't use that word, but they're communicating with the committee. So the first thing everybody wants to do is have this all happen through cooperation.
Right. It reminds me of the McGahn testimony that eventually ended up happening. There were some concessions made on both sides just to get it done. I don't know if any criminal referrals were made. I'm not sure. I mean, I think that was kind of just a legal sort of mechanism to say, oh, look, congressional subpoenas mean something, even if it's 2 years later. But I think the only clock that I'm concerned about running out is the congressional clock, because if Republicans take over in 2022 in the midterms, then and Congress expires and they haven't gotten the subpoenas worked through the courts yet. That's my only concern. But the committee doesn't seem to have that concern. They waited a long time to even subpoena recalcitrant witnesses. And I'm assuming that they have all the documents, or they're going to get all the documents they need, and the witness testimony is just sort of icing on the cake.
Right. And don't forget that all of the other agencies also have relevant documents. And so that's controlled by the Biden administration.
I mean, that's how we got the Eastman memo and the Jeffrey Clark letters, from
Right.
Department of Justice.
So sometimes, okay, so my feeling about testimony is that it isn't what everybody has it cracked up to be, because especially when you're dealing with known liars. So I'm not sure that,
it's not the end all be all of what we need to find out.
Shocker for you. You ready for a shocker? I did my law practice was appeals. So I did appeals. I've read tens of thousands of pages of records. Shocker. Witnesses lie. I just told you. Okay. Witnesses do lie. They lie for all kinds of reasons. I had a client, they lie to protect the fact that they're having an affair. They lie. So witness testimony, unless you get a confession, witness testimony, it's good, but it's not as conclusive as people seem to think it is. And people lying under oath is not, I mean, I shouldn't say it does happen. It shouldn't happen. And when it's caught, it's not like every person who lies under oath in a court is hauled off to jail either. That just doesn't happen. They try to figure out who's lying. And when two people have different stories, obviously someone's lying and the court does its best to come up with the truth. But
yeah, and you're not going to get a 1001 charge, A or B, without documentary proof and corroborating testimony. Like you have, like it's I think should be a high bar, unlike the Sussman indictment. But there are things and elements that have to be in place to charge those 1001 crimes.
So presumably, I mean, look what just came out in the Senate Judiciary memo. They have a lot of evidence. People are cooperating. There are plenty of people who were in the Trump administration who is privy to what was happening, who are willing to talk.
Yeah, and a lot of times, Teri, we don't even go after testimony for targets like Clark or Eastman. We get the supporting testimony of people who are willing to talk, like Rosen and Donahue, and some of the other folks who were going to resign en masse, from the Department of Justice based on what was going on with Jeffrey Clark. And we don't.
Right, and they have a Fifth Amendment right. I mean, the thing is, testimony can be right. People have a Fifth Amendment right, but also now if I were in a position where all kinds of people went in and said I did something bad, and there's documentary evidence that looks like I said I did something wrong, they'll invite me in to talk. So one thing to keep in mind too with an investigation like this, it isn't a criminal investigation.
No.
And so what that means is that your silence can be taken as you're not given. In a criminal case, if you remain silent, nobody can draw any conclusions from that.
Right. But court of public opinion.
But also a congressional, a civil case. In a civil case. So if you're sued for something and there's no criminal liability, and you say I'm not talking, then the jury can draw an inference of guilt from that. Whereas in a criminal matter, they can't draw an inference for guilt. So you see the difference?
Yeah.
So, right. So if you've got, let's say, Bannon, and you've got all these people and all this evidence pointing to the fact that Bannon is guilty, and you invite Bannon in to talk, and he says, I'm not going to talk. It's not illegal to draw an inference of guilt from that. So you can raise a Fifth Amendment sort of defense in a civil case or in a congressional case, but only if you have criminal liability somewhere else.
Right, right. And, speaking of, one last question for you, the difference between congressional proceedings and criminal investigations. There are three elements to an obstruction of justice charge. First, an obstructive act. Second, I think, is nexus to a judicial proceeding, and third is intent. First question, is this the 1-6 Select Committee a judicial proceeding?
Yes, it is.
Okay, so then we've got 1 and 2.
Yeah.
Then, yeah, I think you make a really strong constitutional argument for it.
Yeah.
So we've got, Trump talking to these 4 witnesses and saying, defy the subpoenas. A lot of people are wondering if that can be charged as obstruction of justice. The third piece, though, intent, is the one I'm having a hard time wrapping my head around. I've got nexus to judicial proceeding. I've got an obstructive act. But could this be considered, Trump telling these 4 people to defy these subpoenas, an act of obstruction of justice? Does it meet all 3 elements? Does it meet intent? Could it be considered obstruction of Congress? Could it be witness tampering?
Yes, it could. And as far as intent, intent is the trickiest to prove, as you can imagine. Unless circumstantial evidence is allowed to prove intent. And if it wasn't allowed to prove intent, then the only way you'd ever get a conviction on anything is if somebody confessed. Mm-hmm. Because if you think about it, if my foot is out and someone trips on it, did I intend to trip that person or not? The only way you really know 100% direct evidence would be, I say, yes, I did. That would sort of be direct evidence. But even then, people don't always tell the truth, right? So direct evidence is, I saw you shoot that person, right? Or it was caught on camera. Circumstantial evidence is, we came into the room, the gun was on the floor, the person was dead, and you were standing there. There's no direct evidence that you shot the gun, but there's circumstantial evidence.
Yeah, I always actually joke around that a smoking gun is technically circumstantial evidence.
Technically circumstantial. So the point here is, how do you prove intent? Well, it's not as hard as you think it is, because you don't actually have to read the person's mind or get a confession, because otherwise you'd never get it.
And we have beautiful, beautiful examples in volume 2 of the Mueller report with the obstructive acts. And
Congress would make a referral. That's how they would do it. And at the end of the, if you looked at the Senate Judiciary report that came out, what they said is that they're not doing any criminal referrals yet, something like that, until it's complete. They're holding off judgment on criminal referrals until the whole investigation is complete. So they did talk about possible criminal. And so if they say Trump obstructed justice, or if they say Trump incited a riot, all of these things, what they're going to do is they're going to put the evidence together, and they're going to say, we have evidence that shows all of these things, but Congress doesn't make the charge, right? Then they hand it over to the DOJ, but you don't want a criminal referral from Congress.
No, and I think that if in fact the Department of Justice is currently not commenting on any pending investigations as far as trying to overthrow the election goes, but I had posited that if I were Merrick Garland, I would be waiting for either criminal referrals from the Office Inspector General or criminal referrals from Congress to insulate myself from seeming like political in this matter, and doing that thing that we talked about earlier, due diligence. Give them the 30 days so they don't have that argument to make. But also, the Department of Justice is not supposed to be telling us about open and ongoing investigations.
That's the key thing. Now, people, one of the interesting things, I talk about social media because that's where we know each other, right? From social media. One of the interesting things about social media is that the same people who are saying Trump violated laws and violated rules and violated norms are the same people then sort of wanting the Attorney General to violate rules, because he is not supposed to talk about any impending investigations. And not only that, if they do, they risk jeopardizing. And so people are saying, I had someone on Twitter say, but he needs to reassure us. It's like, no, he doesn't.
And he
does-
did come out recently and make a statement when asked if he was investigating Trump for all this. He said, I'm not going to comment on pending investigations.
Right, but that's not enough. You can't draw anything from that. So we don't know what he's waiting for. We really have no idea. And that's how it should be.
Mhm.
It should be that way, because if he made a comment, then you could poison the whole investigation.
It makes the prosecutor's job really, really difficult. And it also makes it hard to hold a conviction on appeal, which is part of the federal criminal rules, that in order to indict anybody. But I saw the same thing happen when Merrick Garland said, when criticized for the light sentences and light fines for the boots on the ground insurrectionists, he said, because Merrick Garland doesn't have his hands in all of those cases. He's letting his line prosecutors take care of that. And Merrick Garland said, I support my prosecutors and what they're doing. And everyone on Twitter was like, WTF, how can you support these shitty things? And I'm like, oh my God, we have an attorney general that supports their line prosecutors. And I'm not saying there weren't meetings, like maybe he met with everybody and said, hey, what's up with the small fines? We don't know any of that behind the scenes stuff. But to see an attorney general defend the line prosecutors and defend the institution is a far cry from what we had under Bill Barr. And I was personally excited to see that part, but the media didn't point that out.
Moreover, can I tell you my own pet peeve here? I spent my life doing defense work because, actually, for a few reasons, but one is that I always wanted to work for the underdog, and almost all of my clients were not white and were not, I represented only indigents. So I never, except for early on when I worked in a firm, I only represented people who couldn't pay. And I saw firsthand jails and prisons and the whole criminal justice system. And the liberals are not supposed to be wanting long sentences for first offenses. And, it's like people hated me on Twitter for saying punishment doesn't do what you all think it does. And state-inflicted punishment is not something we should be cheering, because if it happens, it's somber, and it's like you say, yes, this needed to happen, but it's a serious thing, and we don't cheer. It's like we don't. It just strikes me as the ugliest part of pitchforks and mobs, and also because remember when the whole defund the police thing started, I thought, okay, finally I have some vindication that the criminal justice system is important, that we have it and we need to use it. But the idea that we're going to take first offenders and ruin everybody's life, it's like,
well, with the two systems of justice, Teri, and I've argued this, we don't want to lower our standards to meet the shitty part. We want to raise the standards to have everybody have equal justice under the law. So when somebody complains that a white person was taken into custody without incident, and then says they should have been shot, they should have been tased. No, everyone else should be taken into custody the same way and treated with the equal respect of the law.
The fact that the system, so one of the things that's sort of ironic here is nobody knows better than I do how unfair the system is.
It's very unfair, but we need to raise our standards, not lower them.
And I know it's unfair, but what you do right is you work for reform. But people take things to this extreme and they say, no white person ever. No. Actually, the majority of people are white in prison. It's just that they're disproportionately, the minorities. It's not like no white people ever get put in jail, or no rich white people. They do. It's just disproportionately poor and minority. So some of these absolutes, like, well, if you're white, you get away with it. No. If you're white, you're more likely to get away with it. But we're working on that. But that doesn't mean that if you've got a law that applies to everybody, and what the guidelines say is this, and the judge and the prosecutors are following the guidelines, then you've got everybody enraged about this. These are the people who say they're pro rule of law. These are the guidelines.
Right. For example, insurrectionist gets 45 days. A Black woman in Texas who voted when she shouldn't have voted on a provisional ballot got 5 years. we don't want to give the insurrectionists 5 years. We want to give no jail time to the woman in Texas.
Exactly. And also you want to address the inequalities in the system, that because that's what plays into the worst stereotypes, that it's not that we really want justice. We want, when they say, it's not like the left doesn't really want justice, they just want to put all the whites in jail. No, we don't. We want justice. We want
Equal
fairness.
justice.
Right. We want justice. But also, there used to be, when you see Texas compared to insurrectionists, it's state by, different states we have 51 jurisdictions. And so different jurisdictions have different laws. So in some ways, you're also comparing apples to oranges. Within the federal system, there used to be a lot more discrepancy in charges. And that's why we have the federal guidelines. So you'll always have a case where Texas will have different rules than Maryland or California. But within the federal system, there used to be a lot of discrepancy. So that the judge would say, oh, that looks really bad to me, give them this. And judges could kind of do whatever they wanted. So we got the guidelines. Now, some of us hate the guidelines because the guidelines we think are too harsh, right? The guidelines are very harsh because the guidelines take away a lot of the judge's discretion. And so it's good because it doesn't allow for the kind of unfairness that used to happen more. But at the same time, some of us always argued that they were still too harsh. So we wanted the whole thing brought down so we don't have a prison culture. America imprisons like a huge, more people than like Saudi Arabia. Like we have like very high prison culture here. So there used to be a lot of discretion. Taking away discretion was a good thing.
Because it was being exploited.
It was being exploited. So when you have people, right, saying, how come they only got 45 days? The judge should have done this because it was bad. Well, if you let the judge say, well, this is really bad, so I'm going to go off guidelines.
What's going to stop them from doing it to disproportionately to, yeah.
Right. So, I understand the frustration people feel, but I think that like the way rule of law actually works is sort of mundane and boring, and it's not as dramatic as things appeared to be under the Trump administration when everything was, like kind of up for grabs. Right. And there was it seemed like there was no law because he wasn't paying any attention to it. But when you actually follow the law, you end up with results that you didn't really like.
Yeah, but it's fact-based. It has to be. And
follow the guidelines. Like we decided that we didn't want to put first offenders in something like this. Even if he was part of a mob that wanted to overthrow the government, what he actually did was this.
Yeah. I think what frustrates everybody is things like Flynn, Manafort, Stone, the fact that Donald Trump has never faced any accountability. He just fails forward. I hope that comes to an end very soon now that he's not a sitting president, but we will see.
We will. And, it's going to go on for a while, and there are a lot of moving parts.
It is going to go on for a while.
And there's a lot of, there's the investigation in Georgia, and there's the stuff with when you say no accountability, I think if you say no criminal accountability.
That's what I mean. No criminal accountability. Because he was impeached twice.
He was, how many autocrats get turned out of office?
Yeah.
I mean, he really made every attempt to stay, and he didn't. And he, the charity things, remember, I mean, there have been he loses most of his cases in court. I don't think right now he would say he's a winner. I think he's in some financial trouble. But yeah, as far as criminal consequences, I've always thought, just as kind of a follow-up to that, I always did think that we have a better chance against him in civil cases because the standard is lower. So civil cases require, like some of these lawsuits being brought accusing him of inciting the insurrection. I think you're more likely to get a finding where the standard is preponderance of the evidence. Criminal cases are hard with people who have insulated themselves. The mob boss is insulated by many, many layers. It's always easier in a criminal matter to get the foot soldier. It's always
the only thing that I'm having an issue with the Department of Justice is why the obstruction of justice charges haven't been And I don't know if they're being investigated at the Department of Justice, but volume 2 of the Mueller report clearly lays out at least 4 counts of obstruction of justice. Why they haven't simply charged that very low-hanging fruit, I don't understand. And nor has Merrick Garland told us that he is not pursuing that or that he is.
Right. And
Yeah.
you're right. I mean, there's a lot. There's, right. I agree with that. Kind of odd. Who knows, right? We might find out that that was such a small potato that they, went for all the other, but or it gets folded in. I don't know, but you're right. That was that's a good question.
Yeah,
And
and that was kind of my thought. It might be part of a larger scheme of crimes, including the pardons, and to try to insulate himself from his attempt to overthrow 2020. It could be an ongoing crime. He keeps criming. The statute of limitations the clock doesn't start ticking until he stops committing crimes associated with the original crimes. But I don't know, that might be a little bit of a stretch. We will see, is I think the point. And we have to keep in mind, Watergate took years. That Fani Willis school administration RICO case took like 4 years in Georgia. It was successful. But it is very frustrating, with this slow moving coup into 2022 and 2024 to not see anything that, substantial. And I think that that's kind of what people are craving. And we haven't seen anything like this in our modern history. So we don't know what to compare it to.
Right. And one of the things that makes it hard, is that sometimes I think it's never going to feel quite enough, because some of the things that he does that are the worst aren't criminal or even illegal. Like, not everything that's bad is a crime.
Mhm.
And so when you get him on taxes or obstructing justice, it's still, I think, not going to feel satisfying to people, because you haven't gotten him on the worst things he did. And sort of the way things work is that some of the worst things he did probably aren't criminal, because I can go around and say, I really want to overthrow the government, and that's not a crime.
But actually taking steps to do it is, but it's also harder to prove. And we saw it with Manafort. They had enough to get Manafort on conspiracy with his handing over polling data to Konstantin Kilimnik. But Team Manafort decided to prosecute on tax crimes because it was a much easier case to prosecute. And those are decisions that prosecutors make on a daily basis.
Also consider the jury, that one of the reasons that they bring something safe, that's by safe, I mean that the evidence is documentary instead of testimonial, because a jury can disbelieve testimony.
Mhm.
And so the Manafort cases were documentary.
Mhm.
And so when you consider the fact that you have to get a jury, and who knows who these jurors are, it's just as scary, really, to have him get found not guilty because of some holdout jurors.
Yeah, and this is a case that, particularly this one, that is, I think it would be worse to lose than to not bring it at all. And it would just be another thing that Trump could run and raise money off of if he was exonerated yet again, quote unquote.
Oh, right.
I didn't
think about that as a fundraiser either. I just thought of it as like, that would be horrible.
It would just be horrible, plain and simple. But and with the Manafort thing, there's, hey, you could still charge him with that conspiracy charge. He wasn't pardoned for that, he. I don't know. I'm wishful thinking, I think, but and if you consider his pardon, which wasn't executed until December of 2020, a part of that whole scheme, then we don't have a statute of limitation that tolls until 2025. So it's like, who knows what they're going to do.
Those corrupt pardons, where the pardon probably stands, the pardon itself becomes part of the evidence of obstructing. And for all we know, it is all going to come out somewhere. There's, like I said, sometimes I do pin a little bit of my hopes on the civil cases, because there's fewer impediments to the investigation. the standard is lower. But you're right, we'll see. What will be really interesting is to see if Trump challenges these documents.
That'll be interesting. Yeah, I actually kind of look forward to that. So we'll see what happens. Thank you so much for this. Everybody look for Teri Kanefield's piece in Just Security. And of course, you have writing all over. And you're a stellar follow on Twitter to get, straightforward information, unfettered. I appreciate your time today.
Thank you. Thank you for having me.